Good morning, friends. G S Phunde's Law Lecture Series welcomes you in a very first lecture called as Salient Features are nothing but the most important characteristic features of the Indian Constitution. Now, the Constitution of India is a unique constitution. It provides for the mixtures of federalism, unitarism, flexibility with rigidity. India has a parliamentary democracy. The Constitution of India begins with the preamble. Preamble is the most important aspect of the Constitution. Preamble contains the ideas, objectives, the basic principles of the Constitution. Salient features of the Constitution have evolved directly and indirectly from these objectives and flows from the preamble. And the Constitution of India has many distinct features, and the basic salient features are: number one, the Constitution is the lengthiest constitution in the world. Lengthy means the bulky or descriptive. The Indian Constitution is the most detailed constitution of all the written constitution in the world. Originally, it consisted of 395 articles divided in 22 parts and 9 schedules. But after the Constitution 92nd Amendment Act 2003, the Indian Constitution now consists of 447 articles divided in parts and 12 schedules. अब आपको ये पता करना बहुत ही इंटरेस्टिंग होगा कि हमारे हिंदुस्तान की कॉन्स्टिट्यूशन दुनिया की सबसे बड़ी कॉन्स्टिट्यूशन है. No America, no Russia, but apart from all the countries, our constitution is the most lengthiest constitution because it is the detailed constitution. Number two, the Indian Constitution has adopted the parliamentary form of government. Now, the Constitution of India establishes a parliamentary form of government both at the center and at the state. The real executive power is vested in the Council of Ministers, whose head is Honorable Prime Minister. This is very important aspect to know that we have followed the British model of a parliamentary form. And the most important essence of the parliamentary form of the government is its responsibility of the legislatures. The president is the constitutional head of the state. Now we are going to switch on number next, that is the unique blend of rigidity and flexibility. After introducing constitution in 1950, first time it was amended in 1951. A rigid constitution is one which requires a special method of amendment of any of its provision, which is a flexible constitution. Any of its provision can be amended by ordinary simple legislative process, which is called as a simple majority. A written constitution is said to be rigid. The Indian Constitution, though written, is sufficiently flexible. The fact that the Indian Constitution has been amended 78 times during the period of 49 years. दोस्तों अभी हमें आगे जाके इस लेक्चर को बहुत ज़्यादा सीरियसली लेना है कि वेदर फंडामेंटल राइट्स कैन बी अमेंडेड और नॉट. इसमें हमें ये सारी बातें डिस्कस करनी है कि अंडर आर्टिकल 368 वेदर फंडामेंटल राइट्स कैन बी अमेंडेड और नॉट. Part 3 of the Indian Constitution, which is the most important, that is called as fundamental rights. It includes of Article 14, Article 19, Article 21st, and which is most important, called as the soul of the Indian Constitution, that is Article 32. Fundamental rights are prohibition against the state. Supreme Court has a power to grant the most effective remedies in the nature of writs. Whenever these writs are violated, those fundamental rights are not absolute rights and they are subject to certain restrictions which are called as reasonable restrictions. Constitution strikes a balance between the individual liberty and the interest of the people. Now, of course, we are going to detail the most important thing, fundamental rights in detail, which starts with Article 12 and which ends with the writs jurisdiction. Now, next important is डायरेक्टिव प्रिंसिपल्स ऑफ द स्टेट पॉलिसी. हम इसे हिंदी में कह सकते हैं कि मार्गदर्शक तत्व या मूलभूत तत्व. द मोस्ट इंपॉर्टेंट एस्पेक्ट इज द डायरेक्टिव प्रिंसिपल्स आर नॉट मैंडेटरी बट दे आर merely an obligatory and it imposes no compulsion of the state or central government. It is kind of a duty. Directive principles are not enforceable. That's why it is not justiciable. The directive principles of the state policy contains in part 6 of the constitution set out the aims and the objectives to be taken up by the state in the governance of the country. Now it will be very interesting to know that directive principles and fundamental rights are supplementary and complementary with each other. There is no conflict of interest. They are working together. That's why it is called as a harmonious construction. Number 7, a federation with centralizing tendency. Being a federal constitution, it acquires a unitary character during a time of emergency. Now, central government is treated like a father, and the state governments are treated like subjects. That's why central government is having a strong tendency of domination. Thus, during the proclamation of emergency, all powers are centralized in the union government, and the constitution acquires a unitary character. Now, during emergency, we will discuss in next lecture that how if reports of a constitutional failure machinery is being submitted by the government, all the powers of the state governments are acquired by the central government. Adult suffrage. Now, every man and woman above the age of 18 years has been given the right to elect representative for the legislatures. This suffrage is wider than all the democratic countries which have given right to vote to their people. In electoral democratic system, every citizen with above the age of majority can cast his vote. Constitution emphasizes on impartial and confidential voting system. As we know, we are in the democracy, and every person is having the most valuable right, which is called as a right to vote. Thereafter, number next, we are the welfare state. Welfare state concept of government that is different from the police state, in which the state plays a key role in protecting and promoting the economic and social well-being of its citizen. Now we are not in laissez-faire state, which is called as a dictatorship, but we are in the welfare state, where the laws are being enacted in the interest of the people. That's why once upon a time Abraham Lincoln called as we are by the people, for the people, and of the people. It is based on the principles of equality, equitable distribution of wealth, and public responsibility for those who lack the minimal provisions for a good life. The basic features of the welfare state is the social security. It makes provisions for education, health service, and housing for the citizen. Now you can see most of the laws are which are being enacted in the interest of the common man. Thereafter, let me switch on the most important, that is an इंडिपेंडेंट जुडिशरी. दोस्तों बस आपको यहाँ पे दो इंपॉर्टेंट केसेस याद रखने हैं. एक केस का नाम है पीएम का केस और एक केस का नाम है सीएम का केस. पीएम का केस मतलब द केस ऑफ इंदिरा नेहरू गांधी वर्सेस जयप्रकाश नारायणन, और दूसरा केस है चीफ मिनिस्टर जयललिता वर्सेस स्टेट ऑफ तमिलनाडु. सुप्रीम कोर्ट ने यह बताया था कि सुप्रीम कोर्ट के सामने चाहे सीएम हो या पीएम हो, एवरीबडी इज इक्वल. इट डजंट मैटर व्हाट पोस्ट दैट पर्सन हैज possessed. Independent judiciary, there is a very simple rule: unless there is a remedy, there is no right, because right without remedy is of no use. For this purpose, an independent and impartial judiciary plays a very important role, and the most important power of judicial review, which is established under the Constitution. It is the custodian of the rights of the citizen. The Supreme Court and the High Court has a power of judicial review. They have a power to declare acts of the legislatures and the actions of the executive ultra vires, and such acts or actions found to be in conflict with the provisions of Constitution can be declared as ultra vires by the Supreme Court. Now we are going to switch on number next, that is fundamental duties. Now, fundamental duties which are not mandatory, but it is an obligation on every citizen, because if you are claiming rights A citizen must enter obligation that he must follow the duties like a law-abiding citizen. Rights and duties are correlated with each other, and every citizen must be bound with those obligations. The Constitution, that is 42nd Amendment Act 1976, has introduced a code in fundamental duties for the citizen. The fundamental duties are indeed to serve as a constant reminder of every citizen that while the Constitution has specifically conferred of the certain fundamental rights, it also requires the citizen to observe certain fundamental norms of the democratic conduct and democratic behavior. If you claim that I have a right to walk on the street, you must know, you must be aware that we are also under obligation to follow the rules of traffic. Thereafter, number next, language policy. The Constitution has also defined language policy. In India, different languages in different parts of the country are being spoken, but English and Hindi are official languages. India has a 22 languages which have been recognized by Indian government, like Assamese, Gujarati, Konkani, Marathi, Sanskrit, Telugu, Bengali, Hindi, Marathi, Nepali, Urdu, Bodo, Kannada, Malayalam, Sindhi, Kashmiri, Manipuri, etc. Now, I would like to switch on number next. That is, the Constitution is derived from the many sources. It will be very interesting to know that our Indian Constitution is derived from the many sources. That's why it is called as basics of the borrowings. The framer of our Indian Constitution borrowed many things from the Constitution of various other countries. Like fundamental rights are derived from the Bill of Rights from United States of America. Parliamentary form has been adopted from the British government. Now next, emergency provisions. There are three kinds of emergencies. That is central government, state government. They are imposing the emergencies during the critical situation like war, internal disturbance. गवर्नमेंट could not perform its function in ordinary times. अभी हमें ये डिटेल में देख रहे हैं जब हम लोग टॉपिक डिस्कस करेंगे इमरजेंसी प्रोविजंस बिकॉज द वर्ड इंटरनल डिस्टर्बेंस हैज बीन अमेंडेड. Therefore, the Constitution contains emergency provisions. During emergency, the fundamental rights of the citizens can be suspended and government can become unitary. Now next, that is federal government with the unitary bias. Now, as I told you earlier, this is very important to know that central government is like a parent and the states are like a subjects. States are like a children, and that's why the Indian federalism center is strong as compared to the states. The center has more financial powers, and the state depends on the center for their economic developments. The center is indestructible and the states are destructible. Well-known Professor K.C. Fair has described the Indian government as a quasi-federal because we seems to be like federal but actually we are quasi-federal. अभी इसके बारे में हम डिटेल में बात करेंगे टॉपिक फेडरलिज्म में. Now next is judicial review. Now the judicial review is one of the most important review which is for check and balance in the powers. The powers of judiciary is to supervise the legislative and the executive branches when the latter exceeds their authority. It is very important that the doctrine varies between jurisdiction. So the procedure and the scope of judicial review may differ between and within countries. Supremacy of the law is the spirit of Indian Constitution. Now next one, that is the most important, the doctrine of basic structure. It is very important to know in Keshwanand Bharati's case, the doctrine of basic structure was evolved. Doctrine of basic structure means certain basic features that cannot be amended, that cannot be altered, or that cannot be destroyed even though amendments by the parliament. And this basic structure is nothing but the objectives which are given in the preamble. The doctrine thus forms the basics of limited power of the Supreme Court to review and strike down the constitutional amendments enacted by the Parliament. When there is a conflict, the basic structure of the constitution will prevail. The basic structure doctrine applies only to the constitutional amendments. Now, before I conclude, it's very important to know that this is the prima facie, the most important salient features of the Constitution. Now, the Constitution is a document which provides legal framework by which the entire country is regulated. The Constitution deals with the structures of the government, rights of the citizen, principle to be followed by the state in the governance of the country. Constitution of India is considered all supreme and has overriding effect over all other laws governing various aspects of the system. That's why Indian Constitution is called as a mother of all the laws. Friends, these were most important salient features of the Constitution. I kindly request you, this is my very first lecture. This is like an experiment. Your suggestions, your feedback, even your complaints are required for the best of our product and knowledge. Thank you so much. We will be coming shortly with a new lecture which is called as Federalism. Whether the Indian Constitution is a federal or quasi-federal. Thank you so much for G S Phunde's Law Lecture Series, Professor Gajanan Phunde. Have a nice day.